Okay, I'd like to go ahead and open up our exec sessions for today with a note first for the committee members. I have been working on a schedule for the rest of this session here. And we will be not meeting at all next week. So it will be a total break. We all need it. I need it. Starting though, when we come back on March 4th, we're going to be hearing 5 bills on that day. And I'll give them to you. I don't know. I've got them written down here. I don't know specifically the order which we're going to be doing, but we're going to be doing them on that day. 1608, 1608, 1605, 1605, 1592, 1592, 1650, 1650, and 1610, 1610. Those will be heard on Monday. Just in case somebody wanted to take another couple days on their vacation break, we're not execing on the Monday.
Time, Mr. Chair.
Now, pardon me?
Time, please. Start time.
Most likely we'll be starting early, probably either 9:15, something like that.
Okay, thank you.
I'll be looking at this. If we want to go a little bit in the afternoon, I could start at 9:30. There's nothing solid down here yet. On Tuesday, March 5th, we're going to start having bills hitting Senate Education. And folks are going to want to go testify there or testify in another Senate bill. And we're going to be trying to exec. So I also have 5 bills for hearing on that Tuesday. So there'll be no conflicts with somebody if they want to get up and go down to Senator Ward's committee and testify on behalf of some bill. So on that day, we're going to be dealing with 1015, 1015. We're going to be dealing with 1654, 1654, 1084, 1084, 1093, 1093, and HR 30. So between Monday and Tuesday, we'll be dealing with 10 hearings. We have 10 hearings left. We've done all 107 hearings. And these are the last 10 of that 107. Going on to the next day, which is Wednesday, March 6th, we're going to start execing. And of the bills, of the 107 bills, there are a total of 35 bills we have not yet execed. So I'm going to be listing, and that includes the 8 bills we have for today. So if you took it out, it'd be 27 left. But we're not going to hit all 8 today. So there's going to be some that are put on hold, and they will carry forward. But on March 6th, I'll just read off these numbers, which you're going to see up here in the calendar. It doesn't mean we have to do them on that particular day, but we will be addressing most of them, or as many as possible. 1084, 1093, 1205, 1298, 1476, 1592, 1605, 1608, 1610, 1616, 1625, 1646, 1650, 1654, 1682, 1691, and HR 30. We're not obviously going to get them all on that day. So what we're going to do, that session will continue on March 8th. That's Friday. Seeing the following week is the week bills have to be out of here, and the following week we only have 2.5 days. And then everything has to be done. Pardon me? Done with all 107 bills. So basically what we're going to be doing then on Monday, March 11th, we're going to be carrying forward executive sessions, which we may have, but I also have set up at the beginning, there will be, I understand, a non-germane amendment for 10:15. So we'll have a hearing on that. Then we're going to go into a work session for the rest of that morning. That's on Monday. And we're going to be dealing with, because there's a number of people here that have not had the wonderful experience of talking about merging cooperative school districts, how to apportionment methods for these, how you seat vacancies, all that. We have bills relative to all this, but we're going to have a meeting that a lot of these agreements for co-ops were written back in 19, might just well be 1959, 1960s. And there's several co-ops that don't even have agreements. And so all this comes into play. And I think everybody should have that background information. Following that, we will go into executive sessions in the afternoon on the 11th, and we will be dealing with perhaps some of those co-op bills and other bills which might be hanging loose that we haven't gotten to. And then on the Tuesday following on 3/12, we'll clean up any remaining bills. There's going to be one bill which we're going to probably have on that particular day, and that's the one dealing with the consolidation of higher education. We're waiting for a task force that's meeting on the Fridays. We meet this Friday, next Friday, and then that other Friday in the afternoon. And we're trying to get some kind of understanding. Do they need some help from the legislature in any areas of statute that may be needed? And I don't have a hot clue on that right now, but we're holding that bill right to the end so that it'll be available for that particular task force. So that's where we're going. We're coming down to the end here. As you can see, we have, when we come back, the Monday, Tuesday, Wednesday, and Friday. And then we have the Monday, Tuesday, basically, to get things done. On that Wednesday, all reports have to be in by noon. So that means there's going to be a lot of writing of committee reports and getting that done. And we leave the morning of that Wednesday open in case there is something that comes up that we have to attend to. It's going to be busy, but if we want that break at the end of the month here, we're going to have to really address these things, as I've mentioned here. Are there any questions on that? Fun and games.
That means we'll be able to take the solar eclipse day off, right?
Well, that's April.
Now that I would hope you get that off anyways, because that's not even in March.
I know, it's April,
Yeah.
but that means, but the point is we'll be done so that we'll be able to take that.
Is it on what
Well,
day?
we got
What?
ten.
April 8th.
It's a Monday?
Yeah,
Yeah, it should be good. Depending upon too what we're getting from the Senate, and I don't know what the Senate is sending us. I had a talk last night with folks upstairs about that, and we're just waiting and seeing what's going on there. Well, so you can be inside here and you're not going to ruin your retinas.
I already have my hotel reserved. I do.
Okay. Yeah, we're not going to have a meeting that day, so don't worry. So
being a smart aleck.
I'd just like to yank your chain a little bit.
I know. Well, and I was yanking yours when I
Okay,
said it.
okay. So with that, let's get on to the bills which we have today. And as we walk down the docket here, we have, do you have the amendment on, okay, 1312. So we're going to hit 1312. This is requiring parental notification of student health and well-being and certain curricula. So let's open it up. Okay. Oh, yeah, making that one.
We just have it on hold. I'll do it.
Okay, I'd like to recognize Representative Cordelli for a motion, please.
Thank you, Mr. Chairman. I would move ought to pass.
Is there a second? Representative Lucas, okay. Motion made by Representative Cordelli and second by Representative Lucas. We're dealing with HB 1312. Representative Cordelli, you're recognized to speak to your motion.
Thank you. Yes, this bill deals with a couple of things. In the top, section 1, it deals with the statute related to materials that should be made available to parents in advance and the ability for parents to opt out of those lessons. And the amendment, which I just am passing around, is Amendment 0774H. And I would move ought to pass on that amendment.
Okay,
Which-
let's stop
Yep.
right there. So we have an amendment in front of us on 0774H. There's a motion made by Representative Cordelli to add that amendment to the ought to pass motion. Is there a second? Representative Lucas seconds the motion. Representative Cordelli, you're welcome to speak to the amendment.
Thank you, Mr. Chairman. This paragraph relates to policies and procedures that are to be set up by a district. And it said specifically that in the original bill that a district may not adopt a policy or procedure that prohibited school district personnel from notifying a parent about their students' mental, emotional, physical health, etc. And the amendment changes that to not removes notifying the parent and changes it to cannot prohibit personnel from answering questions from a parent about those subject areas.
Is there further discussion on the amendment, Representative Woodcock?
Thank you, Chairman Lett. Just as for Representative Cordelli, can you explain what that means? The last part of the statement about not prohibit, I was kind of confused there. Or what you just said.
Basically, school personnel has to be honest with parents. If they ask a question about any one of those subject areas, they have to truthfully answer the parent about the situation. Just that, as has been debated on Parents' Rights Bill, we don't want school personnel keeping secrets from parents. We want school personnel to always be truthful with parents.
Follow up, please.
Yes.
Thank you, Mr. Chair. I'm looking particularly at the part that you didn't say in lines 9 and 10 in your amendment, Representative Cordelli. And it concerns me about the fact that you're also added in there, you forgot to talk about the sexuality of chance services, or have the effect of, you didn't mention that, but that's okay, it's here. If they encourage a student to withhold from parents such information. So basically, if a youngster is questioning their mental health or questioning their gender identity or questioning their feelings, you're saying that they probably shouldn't encourage the student to go to counseling or talk to someone else because they have the effect of encouraging the student to withhold information. Go see a professional because am I reading that right?
It's just indicating that if a parent contacts the school personnel and asks about the student's health or sexuality or changes in related services, then the school personnel has to tell the parent what's going on.
Follow up, Mr. Chair, final
Yes.
question.
Yes.
Thank you. Well, I don't read it that way, and I'll tell you why. Because when you look at end of 9 and 10, it says, or encourage, you have the effect of encouraging a student to withhold from a parent such information. That's not the school teacher, that's at telling the youngster. So once again, if the school professional is saying, you know what, you may want to go talk to a guidance counselor or a mental health counselor or a crisis counselor, before, see, that's what that says you shouldn't do. You can't
And-
encourage that.
Right, right. School personnel should not be encouraging students to withhold information from parents.
But that's the impact as you refer, if I may, Mr. Chair. Thank you. The impact of that is you're not allowing school professionally trained personnel to tell a student, you know what, you may want to go see a counselor, you may want to do this, maybe this is your first step.
I disagree with that interpretation. I think it's just saying school personnel should not be telling a student, don't tell your parent about this.
It doesn't say that. It says not encouraged to go see. That says no counseling.
No, not encouraged.
Wait a minute, Representative Lucas, please,
Mr. Chair. I'm done.
thank you. On lines 12 through 15, is that the exception clause for a teacher that's contacted Health and Human Services or DCYF regarding a youngster?
Right. And they do not have to discuss that with the parent if there is the belief, as it's stated in here, a reasonably prudent person would feel that there was the possibility of neglect or abuse occurring.
Further, Representative Lucas?
Not seeing anything about not being able to tell a kid they can't go to counseling. It says they can't discourage or prohibit parent notification of, oh no, wait, that's the one before that. Or that encourage or have the effect of encouraging a student to withhold from a parent such information. I don't see where it says that they can't tell them they should go see a counselor. Can you?
Chair, look at that.
Pardon me?
She was asking me a question, and I had to go to the chair.
Who's the question to? The committee?
No, Rep. Woodcock, because he had made a statement that I'm not finding.
Do you want to respond to that? You don't have to.
Yes, thank you, Mr. Chair. My point is, Representative Leakis, that point about having the effect of encouraging the student to withhold from a parent such information, that would say to me, if I say to my student here, Miss Heath, you know what, maybe you want to go see the guidance before you talk to your parents, or maybe you want to do this, maybe you want to get some more information before, that would be the exact same thing, encouraging, I'm not telling them to withhold, I'm just saying that says you can't do that, so I'm very leery about that. We have
before you
professionally
talk to
trained
them.
staff in the school for that exact purpose. Thank you, Mr. Chair.
Representative Damon?
Thank you, Mr. Chair. I just want to state that I understand, and please correct me if I'm wrong, the premise of this bill to suggest that currently school staff are trying to withhold information from parents. And I vigorously protest that lack of trust in our trained educators who have the well-being of students first and foremost.
Representative Belcher?
Thank you, Mr. Chair. And I'm not quite sure on the specific interpretation, but I would like to just note generally that it is entirely inappropriate for school personnel to be directing students to healthcare services, including mental health services, without roping the parents into that conversation. Thank you.
Representative Kiskaden?
Thank you, Mr. Chair. I have two questions, if I may. Do you know what the opinion of the social workers, the therapists, and the health organizations are in regards to moving this bill forward?
Are you addressing that?
I'm asking that
Anybody in the
question to
committee?
whoever's presented this bill.
I'm just putting in an amendment to the original bill.
Second question,
Yes.
can you give us an example of a direct violation that warrants this bill?
I'm not one of the sponsors. I
Okay.
don't
I didn't-
have one available to me. at this point.
But we
Representative
have,
Belcher? Did you have another question, Representative Cascade?
well, we have two members on the committee that are co-sponsored, so I didn't know if they had the answers, that's all.
Thank you, Mr. Chair. I just wanted to do the best I can to answer that particular question because my district, in my town, Wakefield, we have a school board policy that explicitly instructs professionals and educators to not be honest with parents about these kinds of criteria.
Mr. Chair, could I just have the reference to that, please?
Yes.
Just
To
what policy?
That policy from
Yeah,
that district?
what is it?
I'll bring it up.
Thank you. Representative Tanner?
Thank you. I actually have two questions. One is, what's a student support form? And also, how would this be enforced? What would you see this as being, how would this actually work out? I guess it just seems so cumbersome. If I'm coaching, somebody sprains their ankle, and I say to the kid, that looks like a pretty bad sprain. You might want to go see the athletic director or the athletic trainer before you go home, rather than immediately going and calling the parent and saying, they sprained their ankle, rush here. Usually it's a minor sprain. Would it violate this? And how would you, as a teacher, know whether you're violating this or not? Or how would the supervisor or whatever? So student support form first? Student support form.
Representative Cordelli?
Thank you. I think if you're dealing with an injury to a student, I think a parent would expect that the school is going to act to have that injury taken care of. But I think at the same point, if there is an injury to a student, that the school should be contacting the parent about that situation.
What about a student support form? Do you know what that is? It's in line 7.
Yeah, the question is, on line 7, there's reference to a support forms, student support forms. Trying to get a definition, what's meant by that?
That's actually law.
Yeah, that is in the original bill.
Yeah.
I mean, that's in the original law, because the original bill is changing what's in bold. And that's not in bold.
No, it's a new paragraph.
It's all new. It's all new.
Okay, maybe I'm looking at the wrong.
Yeah. Further questions on the amendment? We're looking at section 2 here. 9E. Yes, Representative Cornell.
So I don't understand lines, I guess I do understand lines 12 through 15. Would that mean that I, as a guidance counselor who have a relationship with a student and I've known the family for the past 15 years, if I know that telling the parents is going to result in something happening to that child, I have to tell them anyway? Is that what that says?
I don't believe that's what it says.
So I would not have to tell them.
Right, a reasonably prudent person who believes that it would, disclosure would result in abandonment, neglect, or abuse.
And what's the definition of a reasonably prudent person?
I think that there are many legal terms that we have in statute, beyond a reasonable doubt, et cetera, that have a common understanding. I don't think that a definition is required here. If there is any action, I think that it could be determined later if the person was acting prudently in their actions.
Further discussion, Representative Damon?
Thank you. So Representative Cordelli, if you could please expand on what you just said. I'm not clear how a guidance counselor or other school staff would be clear what reasonably prudent is, because as I heard what you just said, it would be determined after the fact. I mean, how is that staff person supposed to proceed if they don't know?
I'll leave it the fact that a reasonably prudent parent, I think, if they think that there is going to be abuse or neglect because of disclosure of information, they would not have to do it or make that disclosure. I think, do we need a definition of beyond a reasonable doubt? Anything like that? I don't see.
Is there any further discussion on this? I'm just trying myself to look up if there's in the annotated versions here under 169C3, whether there's any reference to this language in referring like to DCYF. Is there any further discussion, Representative Heath?
Thank you, Mr. Chair. Just a simple question of Representative Cordelli. Is it anticipated that this information, this bill, would apply to children attending private or sectarian schools for which they receive an EFA? Would this policy hold true for them as well?
I have to go back and look at the original statutes related to school districts, but this specifically says a school district.
Yes, Representative Myler.
Thank you, Mr. Chair. I think one of the concerns I have about this, this would fall under the category of it's in the eye of the beholder. And the vagueness of it, because even if you look at the issue of the prudent person standard, the prudent person standard is also subject to interpretation. And what I might think was prudent, another might not perceive as being prudent. And so this is, I think, this whole section is subjective. And what one person might think is okay, another person may not think is okay. And that's the problem I'm having with this right here, because I do think that that school personnel, I think they do try to be prudent. I think they do try to be direct in protecting the privacy of students, et cetera, as well as dealing with parents. And this language, I think, just kind of muddies that water of interpretation of what would be the standard that would cause a school employee to come under suspect based upon a decision that they might make at that particular time that they're involved in.
Yes, Representative Cordelli.
Thank you. I think that the term reasonable is used throughout our statutes in relation to child custody, et cetera. And even in 169C3, under guardian, it talks about reasonable visitation rights. So, do we want to go back and put in a definition of what reasonable visitation rights are? So reasonable is used throughout our statutes.
Representative Cornell?
Yeah, reasonably prudent person is in both the amendment and the original bill, but in this paragraph, the only change in this amendment is on line 7 and 8. It says answering questions from a parent, and on line 22 and 23 in the original bill, it says notifying a parent. So the only difference in the entire amendment is those two words, correct?
Pretty much.
Further discussion, Representative Cordiello.
Thank you, Mr. Chair. So I was just looking up prudent because, the word, I know what it means, sort of, and looking up cautious, sensible. I would hope that anyone who works in a school who is supposed to have the best interest of the children in mind would be hired to fit that criteria of being a reasonably prudent person.
Representative Lekes, and then Representative Woodcock.
All throughout law, we write general law. We don't write specific law because we can't think of every specific. And if we write very specific law, then it tends to be interpreted as if we didn't include it in the list, it's not included. And if you look at most of the laws on the book, they are general, and there are general understandings of what things mean. Things like, I just lost the word again. Without reasonable doubt. Various things like that we go through all the time. We are told we are to write laws generally because we can't think of every single specific. And so we can't say, well, what exactly? So we have a list of what does reasonably prudent mean? What is reasonably prudent? What is not reasonably prudent? I mean, we don't write law that way. We write law that's general, that gets interpreted. And that's what we do throughout law. So I don't know why suddenly reasonably prudent is, well, too vague when it's as specific as any of the rest of the things.
Representative Woodcock?
Thank you, Chairman Lett. I'd like to go back to Representative Cornell's statement as a counselor and going back to line 14 and the determination that Representative Cordelli made about the disclosure, where it says would result in abuse. If Ms. Heath, if she doesn't mind me using her again, comes up to me and says, Mr. Woodcock, you know what? This is happening to me, or I may be pregnant, or I think I may be gay, or whatever it happens to be. But please, you can't tell my parents yet because they'll kill me. They're going to beat me up. My father beat me. They're not going to allow that in the house. I'm a good whatever I happen to be. So I would say, based on this, then, you know what? Your best health, mental health, and opportunity for lack of abuse is me to keep my mouth shut. And it seems like that's sort of the opposite of what this is saying. So based on that, would that situation be correct, Representative Cordelli? That I would not have to tell the parent then or inform the parent because the youngster, my young 12-year-old friend here, Ms. Heath, would be petrified of being beaten when they went home?
I think that would warrant additional discussion with the student. I think it would involve knowing the student and to some extent their history. If the student has been in the school or in the class before, there might be some indications of some prior family problems. So I think that, the question you ask requires broader information in making that determination. And I think that schools should probably have it.
Seemed pretty simple to me, if I may. It seemed pretty simple.
And I thought my answer was pretty simple.
Okay.
Well, I was sort of beating around the bush, didn't answer it.
Okay, let's
Thank
go
you.
through the chair. Representative Dry?
Thank you, Mr. Chairman. So I'm in the Child Protection Act, Section 169C3, with all the definitions. And throughout these definitions, there's 4 pages of definitions, are things like compelling reason, founded report versus unfounded but with reasonable concern. So there are things that are not defined specifically but have that kind of, there is a reasonable doubt. I think that this is permeates this, that you're looking at your good judgment and acting in good faith. And I think that it's pretty reasonable interpretation of what looking for in the Child Abuse and Child Protection Act.
I'd like to note that in the Child Protection Act, the word suspected is used. You're required, you're mandated to report if you suspect abuse, neglect, etc. And that's, so, from that line could read from a parent if it is suspected that disclosure would result in abuse, abandon, or neglect. There's a number of ways. I think what Representative Cordelli is saying is absolutely so, that, if a reasonable person believes that this could result from communicating with that parent, that there will be further abuse and neglect of the child, obviously you don't want to communicate with a parent on that. But on most situations, the parent should be informed. I don't think most parents would do that, but there are some that do. So suspected is a word that's used right on page 166 of your books. Is the primary purpose of this chapter through mandatory reporting of suspected instances of child abuse or neglect. And that's where you report to proper agency. Representative Woodcock.
But 51A, that's a mandated report, which we all are in schools. That is after the fact. That's after the fact. When we suspect that a youngster has been abused or neglected, whatever it happens to be, it's after the fact. It's not prior to the fact. This talks about prior to the fact.
Further questions? Yes, Representative Tanner, or discussion.
Yes, so I think this amendment and this second paragraph of the bill is something that should reside in local control. It should be a local school board policy and handled at a local level. Parent complaints should be handled first at the school level or with the teacher, and then at the school level, and then at the school board, and so on. And when there is something like this, which is vague, it's very hard, as Representative Myler said, it's in the eye of the beholder. One person, the parent might feel one way, the school might feel the other way. I think that resolving that, or just even having this on the books is like not necessary. Number one, because schools deal with this issue all the time, and number two, I think that there's no way to. I mean, I can see this part being abused or being so vague that it could pop up at any time. And when Representative Leckis said that we want vague laws so that we cover everything, we also want laws that are able to be enforced, that have a reasonable process to it. And this doesn't have it. It usurps at the state level something that happens at the local level and should be taken care of at the local level. And there are processes that if a person is unsatisfied with how it's done at the local, they can go above that.
Representative Cordelli, do you have further information?
Just in terms of this whole reasonably thing, we've had Representative Dry read from current statute. You just referred, Representative Tanner, to a reasonable process. I don't know about, I'm not sure what a reasonable process is. What might be a reasonable process to me might be different than a reasonable process to Representative Dry. So, reasonable is a term that is used throughout our statutes, and I think to try and nitpick it on line 14 is really not addressing what we're trying to accomplish with this, which is simply putting in place statute that requires schools to be honest with parents We've heard about that in prior legislation the past couple of terms. Representative Belcher just mentioned about a policy that has been common in many school districts that's still evidently in effect in his school district.
Any further discussion on the amendment? Representative Belcher.
Thank you, Mr. Chair. The reference was requested and I would like to provide it. I had to go through dozens of different PDFs to find the correct one. SAU 101, JBAB, Transgender and Gender Nonconforming Student Policy. Section 3, Guidance A, Privacy. The board recognizes a student's right to keep private one's transgender status or gender nonconforming presentation at school. Information about its student's transgender status, legal name, or gender assigned at birth may also constitute confidential information. School personnel should not disclose information that may reveal a student's transgender status or gender nonconforming presentation to others, including parents. Moving on to Paragraph 3, when contacting the parent or guardian of a transgender or gender nonconforming student, school personnel should use the student's legal name and the pronoun corresponding to the student's gender assigned at birth, unless the student has specified otherwise.
Thank you. Further questions or discussion on the amendment? Representative Tanny? Terry, excuse me. Thanks, Paul.
Mr. Chairman, as a new member of the committee, I appreciate the wide-ranging discussion here with respect to the entire language contained within this amendment. But I believe that I'm understanding that the language is essentially duplicative of the language that's in the underlying bill, except because no one appeared to correct Representative Cornell, that the substantive change here is with respect to notification of parents or asking or responding to a question that is posed by a parent. And that's the real focus here of this amendment. The burden, therefore, being upon the parent to ask the question, and then the responsibility of the school personnel to respond openly and honestly to that question, but with the exceptions that are noted that we've discussed. That we've discussed. So the change here is from placing the burden upon school personnel to take the initiative to notify parents of any of these concerns that are specified in the paragraph and in the bill, to answering honestly and forthrightly a question that's posed by a parent, and believing that the primary relationship is between the parent and the child and not the school and the child. And because the school effectively is acting in loco parentis and is in an effective trust relationship with the parents, it seems to me that this is an eminently good sense and appropriate change to make because of that relationship. Thank you.
Thank you. Further discussion? Are we getting there? Representative Dry?
Thank you. I'm going to go back to the Child Protective Act again and just say that the primary purpose in the first paragraph is to protect the safety of the child, take such action as may be necessary to prevent the abuse or neglect of children. But I want to take this back to the end here and say that we're not asking a reasonably prudent person to disclose or not. We're asking the school district to adopt or permitting the school district to adopt policies that would permit a school personnel to withhold such information. So it would be incumbent on the school district to make the policy that defined what reasonably prudent means.
Okay, I think we've had enough discussion on this right now. We're going to move ahead. We got a motion on the floor. It's the amendment which we're speaking to is 0774H. The motion is for OTP on the amendment. Representative Cordiello, would you please call the roll?
Vice Chairman Cordelli.
Yes.
Representative Leckis.
Yes.
Representative Terry.
Yeah.
Representative Belcher.
Yes.
Representative Dry.
Yes.
Representative McDonald.
Yes.
Representative Noble.
Yes.
Representative Peternell.
Yes.
Representative Cortiello. Yes. Representative Myler.
No.
Representative Cornell.
No.
Representative Tanner.
No.
Representative Luna.
No.
Representative Heath.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Lane,
No.
Representative Cascadden,
No.
Representative Damon, sorry,
Yes.
and Chairman Ladd.
Yes. Excuse me, no. Yes, excuse me.
Okay, I was a little confused too.
I
Okay.
didn't have my Cheerios.
11 yeas, 9 nays. Correct.
What did you have?
11 yeas, 9 nays.
Okay.
Could I,
Who was the 10 right here?
Right, because she said that.
Yes, you're right. Yeah,
So,
good.
yeah, that threw me off a little bit. Okay.
Representative Cordelli.
yes, I would like to make a subsequent motion of ought to pass as amended with Amendment 0774H.
Is there a second? We have a motion on the table to approve 1312 with amendment 0774H made by Representative Cordelli and seconded by Representative Belcher. Further discussion? Not seeing any. Madam Clerk, please call the roll.
Vice Chairman Cordelli,
Yes.
Representative Lucas,
Yes.
Representative Terry,
Yes.
Representative Belcher,
Yes.
Representative Dry,
Yes.
Representative McDonald,
Yes.
Representative Noble,
Yes.
Representative Peternell,
Yes.
Representative Cortiella, yes. Representative Myler?
No.
Representative Cornell?
No.
Representative Tanner?
No.
Representative Luna?
No.
Representative Heath?
No.
Representative Woodcock?
No.
Representative Hall?
No.
Representative Lane?
No.
Representative Cascadden?
No.
Representative Damon?
No.
Chairman Ladd?
Yes.
10 yeas, 10 nays.
Is there a subsequent motion? Representative Myler?
I move to ITL.
Is there a second, Representative Tanner?
Yes.
Motion made by Representative Myler, second by Representative Tanner to ITL the bill 1312. Further discussion on that from the maker of the motion?
None, thank you.
Second? Not seeing any other further discussion from the committee. Madam Clerk, please call the roll.
Vice Chairman Cordelli?
No.
Representative Lucas?
No.
Representative Terry? Representative Belcher?
No.
Representative Dry?
No.
Representative McDonald?
No.
Representative Noble?
No.
Representative Peternell?
No.
Representative Cortiella? No. Representative Myler?
Yes.
Representative Cornell?
Yes.
Representative Tanner?
Yes.
Representative Luna?
Yes.
Representative Heath?
Yes.
Representative Woodcock?
Yes.
Representative Hall?
Yes.
Representative Lane?
Yes.
Representative Cascadden?
Yes.
Representative Damon?
Yes.
Chairman Ladd?
No.
10 yeas, 10 nays.
Who will be doing the report? Pardon me?
Tanner.
Representative Tanner will be doing the report for ITL, and for OTP, it'd be Representative Cordelli. Moving on. HB 1671. School officials' right of action for damages for false accusations, 1671. No, that, it's a new one. Did you get a copy of it?
Yeah.
It's a new one. Okay, we've had discussion on this bill prior to this, so I'm not going to take any recommendations for a motion right now. I'd like to have Representative Tanner, if you would please. You have two amendments that you brought forward on this bill. One is 0499H, and this one just recently passed out 0801H. Could you please explain the differences and what they're about?
So 0499 was determined to be non-germane. And it was a bill that referenced a totally new section of law than the original bill. And that's why I believe it was ruled germane, non-germane. This one references the exact section that 1671 originally was set to go to, which is 193:40, section 4. And it starts out the same as section 4 in the book. Violations of this section by any educator shall, and not is placed in there, be considered a violation of the educator code of conduct. And then it has the remaining 11 through 14 new language.
Okay,
So it's replacing the whole bill.
so this is the bill.
Right. And it just speaks to section 4 of 193:40, which was where the original bill spoke to that.
So just in response, you're no longer referencing the code of ethics, you're referencing the code of conduct, which is a separate section within the professional codes.
Which was part of this 193 193:40.
Is there any other discussion before I take any action here? Yes, Representative Belcher.
Yes, I just wanted to, I guess, help clarify something, because I'm not sure how this works reading it. There seems to be an issue here to me that this seems to be saying that if an educator violates the code of conduct, but potentially even in an egregious way, that would generally justify employment action or a lawsuit based on any number of factors, that this would essentially provide them with immunity for that by saying that because it's in the code of conduct, it cannot be used against them.
Well, the confusion I have, just the reference to a basis for civil liability is mentioned under the code of ethics, not under the code of conduct. But now we're seeing that switch, and now being under the code of conduct. And this code was developed with a lot of hard work as a result of a task force of educators that came together and worked with the Department of Education to come up with this, and it came back for approval from JELCAR. And it was initiated initially by legislation. So I see this as a significant change from what we have in place. Representative Belcher.
Thank you. And if I may respond, just to add on to what you were just saying, there would be a major difference between something existing within a code of conduct that suggests this should not be used for employment action or civil liability, which is a suggestion within the code of conduct, but it would be an entirely different thing to enshrine that in law, where it may in fact provide a total immunity for that.
Yes.
Yeah, I think it's important to note that, to embellish a bit what Chairman Ladd said, that when the Code of Conduct was created, it was created not to be an abusive system. That there are other channels to challenge employee behavior, etc., but that the code was basically to provide a guideline for how professional educators conduct themselves. But it was never meant to be an abusive system or a liability system. And I think what Representative Tanner is trying to do here is to basically codify the original intent of that code, which was not to be an abusive kind of a system. Like, am I correct, Mr. Chair, as you see?
I would kindly disagree with you that the code of conduct is totally separate and apart from the code of ethics. And there's a code of conduct that references how it's to be used and a process for where you have either a reprimand, a suspension, or the loss of your teaching credential. So it's to address those issues which are basically where they're diverging from everything that a teacher's credential speaks to. So I'm a little confused here as to why we're now bringing over this basis for civil liability and all that when it doesn't speak to in the code of conduct to that at all. It's speaking to that under the code of ethics. And the code of ethics is not what we use to administer the results which can occur from the code of conduct. We've been told over and over by the Professional Teachers Association that they're separate. Now we're trying to bring it together, and I think that's, to me, that's not acceptable. Yes.
So when we look at that section 4 on page 540 in our blue books, it's the original statement was violation of this section by an educator shall be considered a violation of the educator code of conduct that justifies disciplinary sanction by the State Board of Education. My amendment is addressing the fact that the original intent of the code of conduct was never to be used for disciplinary sanction for things like curriculum, pedagogy. It was for, if you want, high crimes and misdemeanors. It was for the types of violations that were considered extreme. And therefore, that's why it speaks to the code of conduct in this particular amendment, because it's a reference to this particular law. And it's a reference to, or my attempt, that this code was made under good faith, and it's being used now as quote-unquote punishment, a punishment factor. And I don't think that was the original intent of the code, and I don't think it's appropriate to have it in this particular section.
Further discussion, Representative Lekis?
I don't have my code book with me. And so I have a question as to the section that talks about suspension, etc. Is that under conduct or ethics?
Conduct.
Conduct. So then, if we've said it should not be the basis for employment action, but that is employment action that's under the code of conduct. So we are, if we adopt this, negating the code of conduct as far as what's in there regarding suspension, etc. Is that correct?
Are you asking me, or I think you're?
I was asking you because you have the book in front of you. But somebody else, anybody else who.
The code of conduct is to deal with unprofessional conduct.
Right.
By the educator in terms of use of technology, of use with students. These categorical areas are responsibility to students, responsibility to school and community, responsibility and use of technology. These are all within ED 510. So it's all identified there, whereas the code of ethics is not dealing with that unprofessional conduct. It's dealing with what is professional. It's the opposite. And so I think that, and when we say in the Code of Ethics establishes a guidance for all school personnel and is not intended to be a basis for civil liability, nor is it designed to be a basis for employment action.
But that's
it's guidance
ethics.
For educators. What do you expect with that? Then on the other side, we spell out what is unprofessional conduct, where then there is ramification which occurs. Either you're reprimanded You're suspended or you lose your teaching credential. I don't think you can mix and match these things
That's
without, this was put together back, and I remember the year we put the legislation forward, but this was put together and there's a prefixing letter here, January 2019, which was completed and sent, and part of this, right, by Christine Brennan and Commissioner Edelblut. And it was a result of teachers working many, many, many months on putting this all together. I don't think that it's wise to, as a result of an amendment here, to all of a sudden do a switch.
Yeah, that's, so ethics says should not be the basis, but conduct is the basis. And so if we pass this, we're saying conduct shall not be the basis for that either. And so we're negating any action.
Representative Cordelli.
Thank you, Mr. Chairman. Under the Code of Conduct, ED 501.01D, specify unprofessional conduct which justifies disciplinary sanctions against credential holders. Reading further into 510.02, unprofessional conduct shall include, but be not limited to, discrimination against the student as is specified in 354 A1. It goes on then the same for community members who might be on school property, discrimination against them. So I think that this amendment would negate all that and be contrary to what is spelled out in the Code of Conduct.
Representative Belcher.
Thank you, Mr. Chair. And I just wanted to clarify further, and I certainly take the representative at her word as to what the intent of this is. But my view is that in order to accomplish what the stated intent of this is, line 12 would need to read, school personnel and shall not be the sole basis for civil liability, nor the sole basis for employment action. But as written, I would assume somewhere in the Code of Conduct, there's a prohibition on, for instance, assaulting students. And as written, if a teacher assaulted a student, because it's a violation of the Code of Conduct, it would appear that this would provide them total civil liability, immunity in such a case.
So
Representative Damon.
Thank you, Mr. Chair. I was going to make this remark anyway, and I think it's particularly relevant following what Representative Belcher just said. This bill, this amendment, is specific to 19340, and if you read carefully 19340 Roman numeral 4, it says violation of this section. It is only talking about the Code of Conduct relative to this section. It is not the Code of Conduct in its entirety for everything that it covers. It's just this.
Okay, I'm going to take a motion right now. I'm going to take a motion from Representative Belcher.
Thank you, Mr. Chair. I would move to ITL on this amendment.
Well, we don't have
We don't have any.
We need a motion on the bill.
Apologies, I would move to ITL on the bill.
Is there a second?
Second.
We have a motion on the floor to ITL 1671 made by Representative Belcher and seconded by Representative Cordelli. Representative Belcher, would you like to speak to your motion?
Yes, thank you, Mr. Chair. And moving to the bill rather than the amendment that we were just discussing, one of the biggest problems I see with this bill is that currently we already in New Hampshire law, both civil and criminal statute, have law for defamation. If somebody has their character defamed, if they're accused of something they didn't do, you can go to court. They can even be criminally charged under the law. But what it appears that this bill would do is it would totally create a different mechanism for somebody to sue and receive damages based on something that does not rise to anywhere near the level of proof necessary for defamation, based solely on the findings of a school board hearing. it would totally turn our system of justice regarding defamation upside down and create a culture of fear to report any possible wrongdoing by coming from the public. And I think that would be wrong.
Is there further discussion on the motion? The motion is to ITL. Further discussion? Representative Cordelli.
Thank you. I agree with the maker of the motion on the ITL motion. But I'd also like to point out that we've had discussion about this with a previous bill last week. And this bill in lines 8 and 9 in the original bill reflects current statute in that a school board decision may be appealed to the State Board of Education, whereas in other legislation we prohibit appeal, that we can't appeal to the state board. So I just find contradictions very interesting.
Further discussion? Representative Myler?
And I think it's important here to note the intent of the original bill. And teachers are subject to frivolous claims by parents at times. And I think the intent of this bill was to provide some kind of a balance between being subject to public accusal by a parent vis-a-vis some sense of balance that a teacher has some right to also provide some cross-claim here. I think that was the original intent of the bill here. Now, notwithstanding the discussion that we've had on here and some issues around the code of ethics and the code of conduct, but I think it's important to note that that original intent was made to provide some protection for the instructor in the classroom to make sure that there is no frivolous kind, or there is an option to respond to a frivolous attempt on the part of a public person.
And I'd like to just read one point regarding the conduct, code of conduct, and it's ED 501.01. It's the purpose. The purpose of a code of conduct, item D, specify unprofessional conduct which justifies disciplinary sanctions against credential holders. That's what this section of law is all about, or of the code. And I think it's important to keep it as it is written, and with the liability and all that left on the other side with the code of ethics. We're mixing apples and oranges here, and when it was put together by educators, they said the code of ethics and code of conduct, both separate. Thank you. Further action or discussion on the bill. The motion is ITL. Madam Clerk, please call the roll.
Vice Chairman Cordelli?
Yes.
Representative Lekis?
Yes.
Representative Terry?
Yes.
Representative Belcher?
Yes.
Representative Dry?
Yes.
Representative McDonald?
Yes.
Representative Noble?
Yes.
Representative Peternell?
Yes.
Representative Cortiello, yes. Representative Myler?
Yes.
Representative Cornell?
Yes.
Representative Tanner?
No.
Representative Luno?
Yes.
Representative Heath?
Yes.
Representative Woodcock?
No.
Representative Hall?
Yes.
Representative Lane?
Yes.
Representative Cascadden?
Motion's
No.
Okay. Yes, sorry. Got confused.
Representative Lane is yes?
Yes.
No.
That's what you said, okay. Representative Cascadden?
Yes.
Representative Damon?
No.
Chairman Ladd?
Yes.
Can I change my vote?
The gavel has not come down yet, so I will close it real soon here.
No.
Okay,
And Chairman Ladd, you already.
okay. So
Okay.
what's the final count?
16 yeas, 4 nays.
Okay, we're going to close the hearing on 1671. There would be a minority report. Who'll write that? Representative Tanner? And
Was that 16-4? Was that the
Yes,
count?
16
16
yeas,
four.
4 nays.
And I'll write that for you, Representative Belcher. Send me your, I know you already got it done before we even talk. Thank you. Okay. Well, both clocks are exactly the same. One's working and one's not working.
Once every 24 hours.
Broken clock is right.
Yeah,
Twice, actually.
Twice every.
yeah, well, that's
Yep, so it's
amazing.
correct now.
Okay, 1382 was, yes, that's one we had discussed. That's the special education support for military compact students, 1382.
Did you get that information?
Yes, there was an email that came to us, and I've got to get my computer.
Oh, they were working on
Yeah.
language from other states, but I don't think
Yeah.
we've gotten all of it.
Yeah, I did see that language. It came in by way of email to us. And I do have some concerns about how they're wording their email. They're saying there has to be an IEP evaluation within 30 days of the student arriving. That's not going to be so if the school, receiving school, accepts that IEP and the IEP is current. You wouldn't have to have an evaluation. You could have an intervention meeting to move forward with the current IEP. You don't have to go through all the testing, test and measurements again. So I do have a concern about the way that's been worded in other states. I can remember when we put the compact together, there were a number of areas within which we did not agree with everything that was in the compact. We definitely agreed with the whole intent and where it was going, but it didn't measure to the way we did things in New Hampshire in terms of special education services. You got to remember, in New Hampshire, we have special education law that supports IDEA, but we go further than it in some cases. And so we reflected that time what we are doing here as our best practice. Representative Lekes.
A suggestion was made to use review rather than evaluation, because with a review, you don't have to do all of the testing and all of that. You just have to look at it and say, yes, this still.
I would
looks good.
suggest that we get that email, disseminate it, and hold this. We don't have to take action today on, but there is some concern there. There's part of it which is fine, the latter part of that bill where there's responsibility for if a parent wins the suit or whatever, the fees are paid by DOE. I have no objections with that, but I do have some concerns about how we do it, with how we function in accordance with IDEA and our state rules and law. So I want to make sure we're conforming to what New Hampshire does, not necessarily what New York State does.
Mr. Chair.
Yes.
Mr. Chair, is it possible to get somebody from the department here that might be able to work with us and answer this question?
Yes.
Because, I mean, there's a potential, I'm surprised nobody's here, because there's a potential liability here on the part of the department for witness, for cost here. And it would seem to me that it'd be good to have somebody here that can answer the content of this as well as the potential liability here.
I think that's appropriate. And I think what we'll also do is we'll put this off when we're doing some of the exec of the other bills in March. And I will, when I'm over there, I will talk to Director Fredette on Friday when I'm over there, and I'll explain what's going on. And I will also take the email that we got from, I'll make sure that's forwarded to everybody on the committee here.
Thank you.
So my suggestion is that we not take any action on that today. Is there concurrence from the committee on that? Thank you. Do we have any other bills?
We were going to discuss 1014, and that's this. 1014.
14. What was it? You said 1014. Yeah, okay. We also want to discuss 1014. This is the voter registration in high schools for the high school students. So let's turn to 1014. I believe that I had the letter, which was from Dave Scanlon,
I have
and
copies. If I can
oh,
hand them out.
let's get that out to everybody so they can all read. And what is coming from Mr. Fitch, from Bud. This is the other one. The first shorter letter comes from Secretary of State Scanlon, and the longer one comes from the attorney, Bud Fitch. And 14.
Mr. Chair, do you have any more, the two departments, you know, have this on the script?
Yeah, I got my original copy. I did not take
Are
one.
there any?
Oh, there may be some on the other side.
Okay.
You have to go now? Okay, right. Right now, we're just doing a discussion, so.
This is discussion information right now. Okay, just look at the first long letter, the one that was written by, I got two, yeah, by Mr. Fitch. He's the General Counsel, Assistant Secretary of State. In that first paragraph, on the second line, it says, everything that you're going to do in terms of registration must conduct it in accordance with New Hampshire law. Obviously, that's so. In the second paragraph down there, it says about, midway through on the right-hand side, in addition to the constitutional obligation to provide equal treatment to similarly situated individuals, it is presently a reality that political officials need to consider whether serving one group of voters or applicants different from another will be perceived as having a partisan bias. And the concern there is if you're in a receiving high school and you have kids coming from different school districts at that high school, and you provide it for one group with the supervisor checklist coming in that represents the town from which they're from, or the clerk comes in, but you don't do it for the other towns, that is discrimination, basically, where you're discriminating and you're offering this service to one, but not to the whole. That's how I read that particular, you may read it differently.
Mr. Chair?
And yes,
Mr. Chair, which letter were you just referring to?
the long one,
The one requested by Mr. Bourne
yeah, it's
back-
P. Bourne.
back in March of
Yeah, and this,
2023.
that was written by Bud Fitch, yes.
So just a question. Was the response from Council Fitch was it directed to the content of 1014? Is that what we're talking about? Yeah, 1014. Or was it directed to another question?
I would have to ask him that.
So
Yeah, I think he's dealing with the issue of registering students at the school.
Right, but 1014 doesn't address that issue. I mean, I'm just trying to understand if.
Now, there's other ways of getting around what we're talking about. And, you know, as being a member of the task force, which is dealing with civics education with Owen LaMontagne chairing that, they're very interested in civics education. And we, last year, as you recall, we passed a bill in the House, Senate, and signed into law that there's a required course, a half-year course in civics at the middle school level, and then again at the high school level. They see this as something that can be very much integrated into that instruction. As far as you as a civics teacher, I would certainly want to invite somebody from the local community to come in, be it a person from the supervisor checklist or the clerk or somebody else from the town, to come in and explain the process that we have in place here in the state for how to register to vote, and that it's the responsibility of everybody to vote. That's important, and that could be done quite easily. You could have folks come in just as you have many other people's invited to come into the classroom. There's some cautions here, though, that I think that need to be addressed, even though it may not be written specifically to this bill. I think it also says that, you know, we're going to treat all the students with equal opportunity. And then the other one from Mr. Scanlon, and it just addressed the issue that you cannot take formal action to accept that any kind of a application for registration at the school. It has to be done by the voter, by committee back at the municipal building. And it says a single supervisor attending an event to receive applications that will not be acted on until a subsequent supervisor sessions is not a public meeting of the board. Therefore, public notice and access to the event are not required. So if one person's going to a school, you don't have to have public notice because it's not the meeting where they approve these applications for voting. That's done back at the town office. I think that's what they're trying to clarify in Mr. Scanlon's letter. Representative Woodcock.
Thank you, Chairman. Well, and I would agree with you, particularly in the last paragraph, because under the board, directing the board of supervisors. So if you put from Secretary Scanlon's letter on 3 and 4, those two paragraphs, it would seem to me that it is applicable and allowable for a high school to hold the event. For example, if Ms. Heath here, the supervisor, at the author event, she would take the applications back to the regular board for final blessing. That's how I read that.
Right, but the other one I'm saying, if there are other students at a school that don't come underneath that particular town.
Yeah, but we're not sure that this, Representative Ludo's point was valid. We're not sure that this March 22, 23 letter is addressing 16, 17. 1004 rather, but we do know that the Secretary Scanlon's letter is addressing 1014, and it says it's okay as long as the board of registrars or supervisors, depending which title they use, does it. That's how I read that.
Well, read the last sentence there in paragraph 3 that's addressed to Mr. Bourne. It says, if it is the case that a high school age students from any of the involved towns go to different high schools and the in-person voter registration is offered at only one, the supervisors need to consider this issue. There are some issues that need to be looked at in terms of fairness.
Yes. That's the supervisors. That's not the.
You would think the school would look at it too, though.
They may, but it's clear that the supervisor is going to be there. That's the whole point of the letter of 2020, April 18th.
Mr. Chair.
Yes, Representative Damon.
There's an amendment upstairs that would potentially address some of these concerns. I thought another person was bringing the copies forward. May I go get them?
Oh, yes, yes.
Thank you.
Mr. Chair,
Okay, we're,
And the motion is?
Mr. Chair?
Mr. Chair,
Representative Cornell.
I think it's important that we know what the letter that Mr. Bourne wrote to the Attorney General, because it says, for those reasons,
Well,
it
the
appears
letter to
unlikely
Mr.
that we
Bourne.
can provide a letter with the terms you seek. We don't know what Mr. Bourne was asking
right.
of the Secretary of State's office. It just, we don't know what he's answering.
Well, if you look in the last paragraph from Bud Fitch, you can see he's really clarifying information as far as
Firearms.
policy. If you're going to do this, some schools may not even allow that to occur.
But we don't know what terms he's asking about. I mean, this goes from supervisors for different students from different towns that attend a school to firearms to, I don't know what Mr. Bourne was asking the answer to.
Well, the first sentence absolutely says it. Thank you for your efforts encouraging voter registration.
Okay.
So this letter is addressing issues associated with voter registration at schools.
Secondary schools,
Yes, Representative Dry.
secondary.
Whether a decision to provide the service of an in-person voter registration opportunity at one out-of-town high school for residents of the town eligible to register to attend that school will obligate to provide it to other out-of-town schools with town service.
Yeah, that's what we're talking about. Representative Belcher.
Thank you, Mr. Chair. I just had a procedural question. I wanted to clarify. Have we taken up a bill yet, or are we just discussing?
We're discussing, we're in
Okay,
discussing.
thank
mode.
you.
Yeah.
Mr. Chair.
Yes.
Yeah.
Representative Leno.
No, go ahead.
It's
If it's all right.
I mean, this may be a larger Pandora's box than we would think that this simple bill would deal with, because I've been informed that we already have schools that are registering students. So, in schools. And so if some schools, you talk about discrimination, if some schools are in fact already doing that and others don't have an opportunity to do that, then that could be a problem. And I think Representative Lane also is on the election law committee, and I'm assuming that this would also fall in the purview of that particular committee.
Yes, we were surprised that we didn't get it. But I can tell you that, and to confirm that some schools, some towns and cities or municipalities go in and register students already. They do.
Yeah, we do know that's occurring, and that's a local decision that can be done in conjunction with your civics curriculum. It can be done in conjunction with a cooperative agreement with the municipality and the schools. The question I'm raising is that we have a number of high schools that receive students from different municipalities. And where one municipality may be doing this and another may not, then you get in and you're registering at that high school. We're not open, this is a service that's being provided for some students, but not all the students within that school. It's different than if you're going to a district which is in the same municipality, like a Manchester. Well, Manchester may even have some kids coming in. The tuition. Yeah.
Mr. Chair?
Yes.
Yeah, so thank you. It's obviously it's clear from the date on the two letters that the letters were preceded the introduction of the bill we're talking about right now. So neither of these letters could have contemplated House Bill 1014. But House Bill 1014 basically directs school districts and private high schools to adopt policies that contain two things. One, informing students of state requirements for voter registration, and B, providing access to and assistance with filing registration applications.
I don't mean to interrupt, but I have a point of order on this. I don't believe there was any advertisement for any sort of a work session on this bill. I think technically to be in compliance, we have to take a motion on this before we can do all of this.
No,
work on the bill.
I
No?
oftentimes in
Okay.
this have had discussion, and we use it also as a discussion opportunity for us when we are executing bills to have a sense of where we're going. Sometimes it's come out that we can come out with a simple tweak and then come back with an amendment that's proper. And with the number of bills, this is different than many of the committees in this House. We have 107 bills. We've had some work sessions on 4 other bills. We're going to have some training on the cooperative school district stuff, but that's about all the time we've had. So this is why I make this exception where we can have discussion. That's been a common denominator here for years, even when I wasn't chairing this particular group.
So, Mr. Chair, if I could finish my remarks. Neither letter appears to be, because of their dates, appear to be directed at the bill where at 1014 that we're talking about right now, and all the bill calls for is for schools, school districts and private high schools to adopt policies with respect to informing students of requirements for voter registration and providing policies for providing access to and assistance with filing registration applications. And clearly the legislature has already established standards for through I'm sure through its election law committees that that apply to voter registration, non-coercion, stuff like that. And we also have the guidance from the Secretary of State's office with respect to how these policies might impact municipality school districts and private schools. We also have the School Board Association that creates draft policies that school districts could adopt, and this I would imagine would become one of those, and would be informed not just by House Bill 1014, not just by the 4 corners of House Bill 1014, but by other laws that are in force right now with respect to voter registration. So I think, I guess what I'm saying is I think the two letters are good background information. There's probably other state laws that are also good information to inform what those policies are going to be. But 1014 is really a fairness type of bill. I think Representative Myler hit it, that some schools are already doing this, but not all schools. And to be fair, for all 165,000 students that are in public school districts, plus another 15,000 students that attend private schools in New Hampshire, that they each receive some instruction in this area. And I agree that I think that could be done, as the chair was suggesting, possibly through civics curriculum too. And there's nothing in 1014 that directs it to be done one way or the other way, or inside or outside civics curriculum. But that would make a lot of sense.
I get what you're saying, but my concern is, I guess, on the first line of all the amendments, including the bill, each school district shall. That's not the way it's working in our state right now. We've heard people discuss earlier here that local districts might be doing this, some are doing, some are not doing it. Why do we have to mandate this shall occur in each district and private high school?
It says they shall have policies.
Yeah, shall have policies. Why? Wait a minute. We're going to tell a private school that they're going to have a policy on this, when in the private school, Holderness School, they're coming from Arizona, they're coming from all over the place.
Can we have
Representative Peterno?
Thank you. 2 points. I forgot the first one. Second one, under RSA 189.22 and our 189.23, this is already required. 189.22 says the Secretary of State is hereby directed to furnish to the State Board of Education such number of copies of the state constitution and election laws as may be necessary.
And 23 says, the State Board of Education is hereby directed to distribute copies of the state constitution and election laws to all teachers of history and civics in the upper grades of elementary schools and to teachers of U.S. history in junior and senior high schools to be used by them in instructing their pupils relative to the laws governing election and voting. These two chapters are from 1937.
Yep. Representative Cordelli, and then we're going to have a motion.
Thank you, and thank you for finding those sections, because I've been looking for them and haven't been able to find them. But that came up in a prior discussion on a prior bill, and I checked with the chair of the State Board of Education and the commissioner, and they said, oh gosh, this dates back to the 1930s. We don't think this is being done, but we will start to do it to make that information available.
Yes, Representative Perna.
I would add that Representative Dry, myself, and another representative had legislation to fund the distribution of these copies because it was something that wasn't being done.
And we know it's not been done for years.
Who did Representative Damon comment on her?
Well, what we're going to do is we're going to have a caucus right now, brief caucus, and then we will come back, take action, and then have lunch. Because I think we're pretty much done our bills right now. So this is the last one. So let's have some time here for a brief caucus, and we'll come back in about 15 minutes.
15 minutes?
Yeah. Yeah.
Write my board and going to
Depending upon time and my brain, I may do that too. So I have one to write.
We had 49 fiscal notes. What makes an early bill if the fiscal note is over $10,000?
Learn something. Learning something new. What'd you learn today?
I should give you the Cliff Notes.
Of course, my family will be very underwhelmed by that factoid. They'll be like, "What does that mean?"
Orient me here.
Yeah, we're reconvening the executive sessions today, and we're also closing down the executive sessions for today and adjourning the meeting. Thank you very much.